Good afternoon, everyone. We're just letting everybody in, so this will take a minute. Okay, so please let me start. So, dear colleagues, it's a great pleasure to welcome you to this webinar on academia and practitioners' perspective on the International Law Commission draft articles on the protection of persons in the event of disasters and the future legally binding instrument. We all know that disasters, often intensified by climate change, affect millions of people every year, with a disproportionate impact on those in vulnerable situations. Recent events remind us of this stark reality. Hurricane Melissa in the Caribbean, the earthquake in northern Afghanistan, floods in Pakistan, and the earthquake followed by Super Typhoon Fangwang in the Philippines have left devastating consequences in their wake. In December 2024, states agreed to elaborate and conclude a legally binding instrument on the protection of persons in the event of disasters by the end of 2027. This landmark decision reflects a clear recognition of the central importance of protecting people affected by disasters within the global humanitarian landscape. States have been invited to submit proposals for amendments to the draft article by the 31st of December 2025. Consolidated proposals are expected in spring 2026, followed by 2 preparatory conferences next year. These milestones will lead to the International Conference of Plenipotentiaries scheduled for the first quarter of 2027. We're pleased to note that the Philippines has formally offered to host this important event. The future legally binding instrument will fill a long-standing legal gap concerning the rights, duties, and responsibilities of all actors involved in disaster risk reduction and management, including the components of the International Red Cross and Red Crescent movement. It holds the promise of strengthening the protection of human dignity, particularly for those in vulnerable situations. It could enshrine obligation on disaster risk reduction and ensure that when disasters strike, humanitarian assistance is delivered faster, in a coordinated manner, and in the right form to save lives. For more than 2 decades, National Red Cross and Red Crescent societies and the IFRC have championed the importance of robust legal and regulatory frameworks for managing disasters and reducing risk, both nationally and internationally. Indeed, the current draft articles were significantly influenced by the IDERA guidelines developed by the IFRC. Since 2003, states have mandated the IFRC and its members through 5 resolutions of the International Conference of the Red Cross Red Crescent to provide advice and support in developing strong and effective disaster-related legal frameworks. We are deeply grateful to our academic partners who will share valuable insights today. These perspectives will help national societies in their auxiliary role to public authorities to advise states as they continue substantive dialogue on this critical instrument. Thank you for joining. I hope you find today's discussion both enriching and inspiring. Over to you. Giulio?
Yes, Isabella. Welcome, everyone. Good morning, everyone. Thanks a lot for Isabel for your kind presentation, as well as for Thomas for arranging it on behalf of the group of national society who are working hard on the draft articles and the negotiation process. I'm also particularly glad to host today a series of academic colleagues who might share their views with regard to the current draft articles and proposal for improvement of the text. I also would like to make the webinar as much as possible interactive. So after this first round of presentation by academics, we should be brief on different clusters of topics. I will be much more than happy to receive your comments, feedback, in this regard, you can write your comments in the chat, or you can simply raise your hand, virtual hand, of course, and then we can make you, thanks to Tommaso, a speaker, so you can make your question directly to the speaker themselves. So just to mention this point. And without further ado, I'm very glad to have today with us Emanuele Sommario, who is associate professor at the Sant'Anna School of Law in Pisa, where she's also one of the editors of the Yearbook of International Disaster Law. And Emanuele Sommario has the task to present the preamble and draft articles 1 to 3, which also contain the definition provision. So Emanuele, up to you to present, please.
Thank you so much. Can you hear me?
Yes.
Great.
Yes.
Yes. So I just wanted to share, as Giulio said, a PowerPoint presentation, a few slides where I simply reported the text of the provision I want to comment upon. Okay.
Yeah, it works.
Can you see them?
Yes,
Can
yes,
you see
it works.
the slides? Great. So, well, first of all, thank you so much, Giulio. Thank you so much, Isabel, and to everyone who involved me in this webinar. Thanks also to all the colleagues who logged in to listen to what we have to say. I don't have much time, so I will go straight to the points that I want to make. I was asked to comment on the preamble and then on draft articles 1, 2, and 3, and then to leave a bit more space to question and answers and to the general debate. So let's start with the preamble, which is a central element of each and every treaty, in the sense that it might prove decisive, especially when it comes to treaty interpretation, because it is usually referred to as the part of the treaty which contains the object and purpose of a treaty, which is important when it comes to interpreting treaty provisions. Although rightly in this case, we do have provisions regarding the scope and the purpose of the treaties for draft articles 1 and 2, but still we don't know whether they will remain as they are, so that the preamble might prove, in fact, very important. And here the preamble basically wants to provide answers to some basic questions. So why do we need a treaty on the management of the risk of disasters? Well, it says that we need it because there are more disasters which are more severe, and because these sort of phenomena endanger the essential rights of individuals which are affected by the disasters. So what can states do to help? There we have paragraph 3. States need to cooperate, to express solidarity with each other. How is this help? Does this help need to be provided? Well, the last paragraph comes into play because the International Law Commission made it clear that there is one basic principle that still needs to be respected in all phases of the risk of the disaster management, which is state sovereignty, with all the consequences that such an important principle involves in terms of the consent, the modalities for international assistance, and so on. My impression is that the preamble, as it stands now, summarizes quite well the fundamental principles at stake. So on one hand, the fact that the treaty is there fundamentally to protect the rights of those who are affected by disasters, but also with full respect of the principle of sovereignty. There's a number of proposals the states have made. Some want to have an express inclusion of the principle of non-intervention. Some want to highlight the importance, to give more importance to fundamental rights. Some want to clarify that the treaty will also apply not only to disaster response, but also to other phases of disaster risk management. My personal idea is that as it currently is, it's probably a good compromise. The only addition I would probably make concerns the fact that certain actors that are mentioned in the draft and are addressed in the draft articles, such as international organizations, regional organizations, the International Federation of the Red Cross, NGOs, are not mentioned in the preamble. So one suggestions which could be considered by states is to include these actors also in the preamble, because these are in fact actors that might be fundamental in framing activities concerning disaster, the management of the disaster risk. Now let's move quickly to Article 1, quite straightforward. It defines the scope of the future treaty. It simply says that it applies to the protection of persons in the event of disaster. And here what I think is important to stress is that, sorry, I'm having problems with my screen. The terms or the formulation that has been used is quite straightforward, I would say. It refers mainly, by reading it, to persons affected by disasters. And some states have stressed the fact that it might look as if the treaty mainly concerns the disaster response phase. Now, in actual fact, if then you read draft Article 2 and especially draft Article 9, then it is clarified that the treaty also applies to other phases of the disaster management cycle. Yet some states have proposed that the text of the treaty concerning the scope also reflects this element. And so they suggested that the text should be modified to explicitly include also other activities such as disaster prevention, disaster preparedness, and so on. But we will get back to this point later on when we talk about the definition of disaster. The next draft article is draft Article 2, which instead explains the purpose of the treaty itself. So what do we intend to achieve by concluding a treaty concerning on the protection of persons in the event of disaster? And here too, the text is quite straightforward. The idea is that the intent is to provide assistance to all persons concerned, taking into account their needs, but also their rights. So there's this tension between, let's say, the rights-based approach to assistance and the needs-based approach, which I think the text here balances quite well, I would say. The underlying, perhaps one issue that has raised concerns was the fact that again, the different phases of the disaster response cycle, the disaster risk management cycle have not been clearly addressed. So some states have suggested that they should be spelled out. Another element which I think is important here to stress is that it refers to all persons, meaning that there shouldn't be any discrimination in the provision of assistance based on nationality or any other status. And again, this provision doesn't seem too problematic, I think. What might be a bit more problematic instead, and I will be devoting to this article the next 5 minutes, is the provision containing the various definitions that are then used in the rest of the treaty. And in particular, the definition of the term disaster. Now, it's been a very long process for the Commission to identify the definition it came up with. You can read it here: a calamitous event or series of events resulting in widespread loss of life and human suffering, distress, mass displacement, or large-scale material environmental damage, and so on and so forth. What is important to stress here is that the element of mentioning calamitous events means that these events must be of a certain importance. They must reach a certain threshold. It doesn't distinguish between natural or human-made hazards. So all sorts of disasters are included in the definition. It also doesn't distinguish between sudden onset and slow onset disaster. That's another point that the Commission has made in the commentary. It does, however, define the term disasters by reference to certain elements that are also present in many other definitions. So first of all, it says that the event must be calamitous and that it must cause a certain degree of damage. And they identify the values which need to be protected in human life, the avoidance of mass displacement, and in material and also environmental damage. And so, for instance, certain types of damage, for instance, damage to cultural goods, for instance, is not explicitly included. One thing on which many states have insisted is that some parts of the, let's say, the definition is missing some elements that are instead discussed in the commentary. More specifically, the fact that taken as it is, the definition might be thought or might be, let's say, might include also social phenomena or phenomena connected to, let's say, human violence, including armed conflicts. And so many states and many organizations have raised the point that armed conflicts should explicitly be excluded from the scope of application, well, from the definition of disaster, which also means from the scope of application of, if you wish, of the draft articles to a certain extent. Again, let's say one can have different positions on that in the sense that the issue is also regulated in the concluding provisions where the relationship between the draft articles or the treaty and other treaties, other rules of international law is defined. What I simply wanted to flag is that this has been an issue, a contentious issue in the discussion within the Sixth Assembly. Another, and then I finish, another point which has been made is that probably some of the adjectives which have been included in the definition, especially close to words such as, I don't know, great human suffering, large-scale material damage, and so on, it was questioned whether they are really necessary, because then you also have the final part of the provision which says that these calamitous events must seriously disrupt the functioning of society. And so only significant amount of casualties, large-scale destruction, huge losses seriously disrupt the normal functioning of society. So one could think whether retaining these adjectives, as I said, is really necessary. And well, there are other issues that we maybe can discuss later on, but for now, I think I concluded. Thank you.
Thank you, Emanuele. And basically, as mentioned, we'll pick up a question at the end of the different presentation of the set of presentations, so we might have a bit more comprehensive overview of this first set of draft articles. And now Doug Kubi, who works at the University College of Cork and is further editor of the Year of International Disaster Law. He might address the human dimension of the draft articles, or namely draft articles 4 to 6. Doug, over to you.
Excellent. Thank you very much. And I'd like to thank Isabel and Tommaso and the Federation, but particularly Giulio Bartolini, for inviting me to present on the human dimension of the draft articles. As Giulio mentioned, that's articles 4, 5, and 6. I'm also conscious of the time constraints, so I'll begin with some general comments, and then we'll focus briefly on each of the articles. And so to begin with, it's noteworthy that the draft articles, and by extension, the proposed internationally legally binding instrument, were deliberately titled for the protection of persons in the event of disasters. So while sovereign states remain at the core of international law, the obligations of states must be read through the lens of the rights of individuals affected by disasters. So Articles 4, 5, and 6 therefore reflect the fundamental rights of individuals, families, and communities who are the most affected by any disaster event. Now, while few, if any, states would deny the need to protect persons affected by disasters, we know from experience that many people don't receive the levels of support and protection that they require, either due to operational challenges or deliberate policy choices by both affected and donor states. There are funding implications for any risk reduction and assistance measures, yet evidence shows that prevention is better and cheaper than humanitarian responses after a disaster has occurred. The human dimension of the draft articles is therefore woven into both the provisions on disaster risk reduction as well as the provisions on international cooperation and response. Therefore, as Emmanuel just noted, a more explicit focus in the proposed instrument on the full disaster risk management continuum would be beneficial throughout the instrument. Individuals, families, and communities most affected by disasters must remain the central focus of the negotiation process, particularly in the face of the growing threat of climate change, even if many of the provisions by necessity address the role of state sovereignty and technical requirements for interstate cooperation. So those general comments lead us to the first of the three articles under consideration, Article 4, Human Dignity. I should say I don't have slides in the way that Emmanuel has, but hopefully each of these articles are fairly short, so I'll read them out and then discuss some of the issues that arise. So Article 4 in Human Dignity reads, the inherent dignity of the human person shall be respected and protected in the event of disasters. And the inclusion of the principle of human dignity in an operative article, as opposed to simply a reference in the preamble that Emmanuel was just discussing, is of importance and legal consequence. It's therefore helpful to quote from the ILC commentaries to this article. They noted, in the context of the protection of persons in the event of disasters, human dignity is situated as a guiding principle for any action to be taken in the context of the provision of relief assistance, in disaster risk reduction, and in the ongoing evaluation of evolution of applicable laws. The commentaries continue by noting that the principle of human dignity undergirds international human rights instruments and has been interpreted as providing the ultimate foundation of human rights law. And I think few would dispute this point. Indeed, the principle of human dignity is expressly included in both international human rights and humanitarian law treaties, as well as a wide range of other international legal texts and soft law texts covering humanitarian action. However, certain questions are raised regarding the legal limitations of its inclusion in the draft text, as well as who the duty bearers of any obligations are that arise. So first, one can review the placement of the principle within the draft articles. By way of comparison, dignity is mentioned twice in the preamble to the UDHR, the Universal Declaration of Human Rights, as well as 3 times in operative articles. Likewise, dignity is mentioned twice in the preamble to the International Covenant on Civil and Political Rights, as well as within an operative article. There's therefore strong precedent for the inclusion of human dignity within the body of treaties, not just in the preamble. This therefore raises the question of what legal obligations the inclusion of the principle elicits. Drawing once again from the commentaries, the ILC highlighted that the language of Article 4 is intended to cover both positive and negative obligations. As they note, the terms respect and protect connote a negative obligation to refrain from injuring the inherent dignity of the human person and a positive obligation to take action to protect human dignity. The commentaries continue by giving the example of domestic legislation to prescribe the activities of third parties which might violate human dignity. It's therefore clear that the ILC viewed the inclusion of Article 4 on human dignity as leading to substantive legal obligations and not simply a pious invocation of the principle. So this then leads us to address who the duty bearers of such obligations might be. The draft articles are premised on the primary responsibility of the affected state, so it's no surprise that they viewed the obligations arising from Article 4 as imposing a requirement to undertake proactive measures on the part of the affected state, as well as on states which offer assistance. More complex is the recognition of the wide array of intergovernmental and non-governmental actors who engage in humanitarian activities. The commentaries highlight that Article 4 triggers obligations for all assisting actors, as defined in Article 3, which includes the definition of assisting actors, and within that definition, that includes non-state actors. So in other words, the legal obligations of Article 4 apply to both states and some non-state actors. Notably, the Federation hasn't proposed any changes to this article in its analysis, and I think that reflects a broad level agreement with the current wording of Article 4. So now I want to move on to look at Article 5 on human rights, which reads, persons affected by disasters are entitled to the respect for and protection of their human rights in accordance with international law. And it's interesting to note that the ILC Special Rapporteur, Eduardo Valencia Ospina, didn't initially suggest a separate article on human rights, and instead he focused on the human dignity and humanitarian principles. But in 2010, the ILC Drafting Committee proposed an independent article on human rights. While one can argue that it's axiomatic that human rights apply in disasters, there is a benefit from including a specific reference to human rights to maintain a clear focus on the protection of persons within the text. The current language is deliberately broad, as the ILC felt that a more complex article setting out relevant rights in disasters might paradoxically lead to a view that rights not referred to in the article were less relevant or inapplicable. I would generally agree with this approach. However, there are some amendments which could be made to strengthen the article. First, a more explicit focus on the disaster risk management continuum would be helpful. The phrase persons affected by disasters could be interpreted as focusing primarily on post-disaster response activities, and so clearer language regarding the applicability of human rights law at all stages would be appropriate. Next, human rights law includes allowable derogations and limitations, and in times of public emergency, some rights may be restricted, as we all saw, the right to travel and social gatherings during the COVID pandemic. However, the universality of human rights could be reinforced through the addition of a reference to all human rights in Article 5. As the Interagency Standing Committee's operational guidelines on the protection of persons in the event of disaster set out, a wide variety of substantive and procedural rights are applicable in a disaster context. So it's important that the language of Article 5 remains strong, as respecting and protecting the human rights of persons affected by disasters is a core function of the proposed legally binding instrument. We also need to ensure that the language can stand the test of time. Unfortunately, it appears that the implementation of human rights law has fallen out of favour in international relations. It's therefore essential to ensure that these references to human rights remain in the proposed legally binding instrument. Finally, I want to move on to discuss Article 6 on humanitarian principles, which reads, response to disasters shall take place in accordance with the principles of humanity, neutrality, and impartiality, and on the basis of non-discrimination, while taking into account the needs of the particularly vulnerable. I'd like to commence with an overarching comment on avoiding silos in international law. The International Law Commission commenced examination of general principles of international law after finalising the draft articles on the protection of persons in the event of disasters. It's therefore important to ensure coherence between ongoing and completed work of the Commission. The importance of humanitarian principles was expressly highlighted in the commentaries to the draft articles. Despite noting that the Commission did not find it necessary to determine whether these principles were also general principles of international law, the commentaries refer to them as core principles recognised as foundational to humanitarian assistance. The express inclusion of humanitarian principles in the draft articles is therefore to be welcomed. The Federation has argued that establishing a positive law basis for the humanitarian principles in disasters would be valuable at a time when there is significant pressure on them. I would agree with this statement. However, several questions arise from Article 6. First, it's generally recognised that there are 4 humanitarian principles: humanity, neutrality, impartiality, and independence. The omission of independence from Article 6 has been noted by both commentators and states, and so should be included to ensure coherence with relevant UN General Assembly resolutions and other texts. Likewise, non-discrimination is generally viewed as comprising part of the principle of impartiality. And so to avoid confusion, the Federation has proposed the inclusion of the words "and in particular" before the reference to non-discrimination. The Federation has also proposed amending the start of the article, i.e. response to disasters, to highlight that humanitarian principles apply at all stages of the disaster risk management continuum. The final clause of the article, which reads, while taking into account the needs of the particularly vulnerable, perhaps raises the most questions. In particular, the classification of groups of people as vulnerable has been critiqued widely. So while it's helpful to see a specific reference to vulnerability, it's also important to note that many persons affected by disasters have extensive capabilities as well. For example, Professor Natalie Baird has highlighted the untapped expertise of many older persons affected by the Canterbury earthquakes in New Zealand in 2010 and 2011. Conversely, over half the people killed by the Valencia flooding in Spain last year were over the age of 70. If Article 6 is to be expanded to address the complexities of vulnerability and capacity, I would encourage a coherent approach to international law, and relevant lessons can be learned from the inclusion of dedicated articles on situations of risk in the UN Convention on the Rights of Persons with Disabilities, and regional instruments such as the African Union and Inter-American Conventions on the Rights of Older Persons. Of note, this should also be reflected in the ongoing negotiations for the proposed UN Convention on the Rights of Older Persons. I'll stop my comments here, but I'd be happy to expand on these during any of the subsequent discussions.
Thanks a lot, Doug, for this very insightful analysis of this key provision of the project. And now we have Jane McAdam. She's a professor at the University of Sydney. Of course, due to timing zone, it's impossible for her to join, but she sent us a very well done recorded video. So please, Tommaso, thanks a lot for taking care of it.
Thank you very much for inviting me to address you today. My name is Jane McAdam, and I am a Scientia Professor of Law and the Director of the Evacuations Research Hub at the Caldor Centre for International Refugee Law at the University of New South Wales in Sydney.
Worked well until now. Tommaso?
The main purpose of my intervention is to explain why the full spectrum of the disaster cycle, from risk reduction through to recovery, should be clearly encapsulated within these provisions. Article 7 sets out the general duty to cooperate, while Article 8 provides a list of examples of cooperation in the response to disasters. So firstly, let's look at the broad duty to cooperate. As the International Court of Justice affirmed in its advisory opinion on climate change earlier this year, the duty to cooperate lies at the core of the Charter of the United Nations. The court also said that it's a central obligation under the climate change treaties, and in the context of climate change, that states have a customary obligation to cooperate. This is relevant to disasters since climate change will affect their intensity and frequency. Specifically in the disaster context, the duty to cooperate applies across all stages of the disaster cycle, covering disaster risk reduction right through to response efforts. While the Sendai framework emphasises that each state is primarily responsible for disaster risk reduction, it also stresses that the reduction of disaster risk is a common concern for all states, and the extent to which developing countries are able to effectively enhance and implement their national disaster risk reduction policies and measures in the context of their respective circumstances and capabilities can be further enhanced through the provision of sustainable international cooperation. The UN General Assembly resolution that decided to create the new treaty on the protection of persons in the event of disasters noted the importance of promoting international cooperation between states in the areas of disaster risk reduction, including disaster prevention, mitigation, preparedness, response, recovery, and rehabilitation. In other words, right across the disaster continuum. In earlier versions of the draft articles, the International Law Commission had included a standalone provision entitled Cooperation for Disaster Risk Reduction, which stated that cooperation shall extend to the taking of measures intended to reduce the risk of disasters. It was said to be based on states' obligations under international human rights law, particularly the duty to protect the right to life, as well as principles of international environmental law. The ILC's commentary noted that such cooperation would include things like the conduct of risk assessments, the collection and dissemination of risk and past loss information, and the installation and operation of early warning systems. This language is now reflected in Article 9, but it's framed as disaster risk reduction activities rather than as forms of international cooperation. Now, when the ILC's original standalone provision was later removed, its central idea was incorporated into a different provision, which stated that the duty to cooperate shall extend to the taking of measures intended to reduce the risk of disasters. Ultimately, this too was dropped because it was thought that the need to cooperate on disaster risk reduction measures was implicit in the general duty in Article 7, and that an integrated reading of all the provisions would underscore that it was still encapsulated. Even so, Article 8, with its illustrative examples, is entitled Forms of Cooperation in the Response to Disasters, which may imply that it does only focus on response. The examples listed there too are all very reactive, rather than about proactively cooperating to build capacity to respond to disasters. This is why I think it would be helpful for the treaty to expressly acknowledge that international cooperation on disasters does include cooperation on prevention and preparedness. This could be done either by making clear in Article 7 that the duty applies across all phases of the disaster continuum, and/or by incorporating examples in Article 8 of disaster risk reduction activities. And indeed, the IFRC has proposed this. Managing disaster risk is an investment in people, communities, and infrastructure. It also makes financial sense. Studies show that each dollar spent on disaster risk reduction brings an average return of $15 on averted recovery costs. The new treaty provides an opportunity to reflect that commitment by expressly recognising the importance of international cooperation across the disaster spectrum to prevent, prepare for, respond to, and recover from disasters. It also provides an opportune moment to think carefully about how this treaty connects to the Sendai framework and its successor framework, which will be developed over the course of the next few years. Turning now to Article 8, even though this provision provides an illustrative rather than exhaustive list of cooperative measures, I think it would be prudent to include some examples of how states can cooperate on disaster risk reduction. When the ILC was engaged in its initial discussions, the IFRC had proposed that it include information sharing, joint simulation exercises, and dedicated financial support. The IFRC has now added to this list assistance with evacuations, picking up on a recommendation that my colleague Thomas Mulder and I made earlier this year in a policy brief about the treaty, which is available on the Caldor Centre's website. Given that disasters account for the majority of internal displacement each year, we were struck by the draft article's silence on measures to avert or respond to displacement. Indeed, the text doesn't mention displacement at all, apart from noting that it can be a possible defining characteristic of a disaster. By including express references to displacement, the rights and needs of displaced people would be more clearly recognised as a core part of disaster risk reduction, response, and recovery. There are a number of places where this could be referenced, but one obvious place is in Article 8. We argue that this provision should include assistance with evacuations, including across international borders, as well as providing access to humanitarian and/or protection visas, among the examples of international cooperation. When local authorities are overwhelmed, the support of assisting actors is crucial in facilitating and conducting evacuations, as well as in providing basic necessities such as food, water, medical care, and shelter to evacuees. International cooperation is often indispensable for responding to the needs and rights of displaced individuals and communities. Well-planned evacuations can play an essential role as a protective disaster risk reduction measure, in line with states' obligations to safeguard the right to life and to protect the human rights of displaced people. Thank you very much for your attention.
Thanks to Jane. Of course, we could not present directly her my comment, but it was very clear presentation. That's also Tommaso to take care of it, and of course, I will take care of any potential question participant might have in this regard. Now we move to a further provision which was already mentioned several times in order to emphasize its crucial role with regard to the overall framework of the draft articles, which are basically the provision dealing with disaster risk reduction. It's a single provision, but it's a complex provision to address, and I'm very glad that Marie Arrozon-Storier might be with us today because she's a real expert on disaster risk reduction. She's also research at the University College of Cork, another editor of the Yearbook of International Disaster Law. And so, Marie, please, you have the floor.
Thank you, Giulio, and thank you to Giulio, Isabel, and Tommaso for kindly inviting me today, and to all the colleagues involved in organizing and contributing to this seminar. It's really great to be here. So first of all, it will probably come as no surprise that I consider it absolutely essential to include DRR in future instruments on the protection of persons in the event of disasters. And I was really unsurprised, although very glad to hear my colleagues here already setting out how it could be better integrated throughout a potential new instrument. And I'll try here to not repeat their comments, but rather stay brief and focus specifically on Article 9. So disaster risk reduction and disaster risk management and governance are uniquely placed to address accumulated risks from various types of hazards and vulnerabilities in a holistic manner. And to include DRR in the forthcoming instruments would also work very well with and strengthen the implementation of the Sendai framework and its expected replacement post-2030. And although it was perhaps in the early days some discussion of whether or not it should be included in the ILC draft articles, by now, the inclusion of DRR in a future convention is not particularly controversial at all. There's only, from what I have seen, a single state that argues hardly that DRR actually falls outside of this scope. And in addition, there's a small number, very small number of other states that have raised some concerns as to whether such an obligation should be binding, and they might prefer a softer language around it. Apart from that, it's very clear otherwise that the vast majority of states are now in favor of including a binding obligation on DRR. And that is partly because, of course, the developments that have happened in the last decade or so, and states have continued to increase their engagement with DRR and the adoption of various measures, including relation to legislation and governance over recent years. So, for example, we can see the 2023 political declaration of the high-level meeting of the midterm review of the Sendai framework, where states agreed to ensure that disaster risk governance is supported by legal and regulatory frameworks, policies and plans at all levels. And also, the UNDRR reports that by the end of last year, it was 131 states had reported that they had national DRR strategies in place. Now, what is really significant about this is that number was only 55 10 years ago. So in 2015, at the adoption of the Sendai framework, only 55 states in the world had a national DRR strategy, and we're now at 131. So this has the twofold effect, of course. First of all, it indicates this change in the approach to DRR by many states and DRR's importance, but it also, from a legal perspective, helps contribute to the strengthening of the existence of a customary international norm to reduce the risk of disasters. So the question really now is, how will a DRR, or should a DRR obligation be framed to ensure that it both meets its goals while still being then also agreeable for signatories? So As has been discussed already in relation to particular cooperation, there have been some considerations of where to put certain wordings, and there's been very careful consideration as to how to formulate obligations around DRR. And that means that draft Article 9, as currently stands, is formulated in a way that it could be palatable also for slightly more hesitant states. And it means that it's a relatively good starting point to start looking for a formulation. So in draft Article 9.1, which sets out the core obligation here, it states that each state shall reduce the risk of disasters by taking appropriate measures, including through legislation and regulation, to prevent, mitigate, and prepare for disasters. Now, this is clear that this is an obligation of each and every state, but it's also clear that this is a duty of action, not result. There has been 1 or 2 states that have had some concerns around whether this could kind of penalize states who are affected by disasters, but the current wording is a clearly one of a duty of action. But also the use of the word appropriate in appropriate measures also serves to account for these highly different activities and actions which will need to be taken dependent on the context for a specific state. And unsurprisingly, there have been states here who have mentioned the importance of considering the different capabilities and capacities of states to prepare, mitigation, and prevent for disasters. Some have sort of highlighted this a little bit in line with what you can see in the climate sphere in terms of common but differentiated responsibilities. But again, this could be incorporated into the current wording of appropriate measures. Also, it's important to highlight that this inclusion of legislation and regulation is really important and should definitely be kept. Some have also suggested adding additional measures such as policies here. The only thing I will say about that, I think it would be absolutely great to have. My only thing to flag there is to make sure that if that is done, to not lose the reference to any binding law. So really keep the reference to legislation or regulations as well. Turning to these principles then of prevent, mitigate, and prepare. So while the principles of mitigation and preparedness have largely developed as specific DRR concepts over the last few decades, the principle of prevention has a long existence in other fields of international law. And it does manifest itself in slightly different ways in different areas of international law. So it's important just to remember that, for example, when we talk about prevention of a breach of the right to life in human rights law, that could be fulfilled through what is here concerned, preparedness measures, such as, for example, evacuations of affected areas before an imminent disaster or such, which is very significantly different from the meaning of prevention of disasters as is defined in the commentaries, which is drawn from the terminology from the UN Office for DRR. I would also just like to highlight this and really, really stress that the inclusion of prevention is imperative moving forward. And also it would align an instrument with the Sendai framework and other relevant frameworks. It would also importantly, very importantly, relieve some anxieties for states who are concerned that the causes of disasters would be forgotten about, in particular in relation to climate change. And some states have flagged this. So I would strongly encourage everyone to work to keep this in Article 9 or whatever the article may be down the line. There have also been some suggestions here about adding recovery as well. And I think this will really come back to discussions that were raised earlier around the purpose and scope of the convention. So I think if there's agreement that recovery is included in the scope of convention, which I would certainly be in favor of, then it should also be included here. However, if that is a decision taken earlier on that is outside of the scope of the convention or instrument, then it would obviously be very difficult to argue for its inclusion in this article. And this also leads to perhaps an even bigger question around the concerns around the lack of clarity of the scope of the obligation, because DRR can be so many things. And there have also been then concerns raised with the uncertainty around the definition of disaster. So I can see moving forward, and we have seen some states raising this already, that there will be a strong connection between this discussions around draft Article 9 or Article 9 and the definition of disasters as currently set out in 3A. So I think those are likely to be connected moving forward as well. And that is just one of the many examples where we can see how important it is to really consider this instrument holistically, right? And also, speaking of scope and clarity of obligations, we have then in draft Article 9.2 currently the examples of measures. And what's important there is that the small number of measures that are currently listed are illustrative. And that can be seen in the current wording of include, but it's also very much highlighted in the commentary. There have been various suggestions by states and, of course, the Federation to add more specific measures to Article 9 for enhanced effectiveness and clarity. And while that would be absolutely great, I think one thing to really highlight here is that it's very important that this provision remains open-ended, because we continue constantly to gain greater understanding of disaster risk and the appropriate measures to reduce it. So we need to keep that open so that it doesn't discourage states from, of course, following later developments. I could actually wrap it up here in the interest of time. I just want to really stress again how important it is to include DRR, but to include it throughout in a much more holistic way. We have a chance now to rethink and to not make it, as has been highlighted a little bit, almost like an afterthought that was in there, was taken out, came back, and have not really found its solid place in the current text. And I think this is a great opportunity to revisit that and make sure that it's comprehensively included. Thank you.
Many thanks, Marie, for this presentation, which highlight one of the very relevant provision we might have to foster in the current negotiation. Another point is that, moving to the next speaker, is that the draft articles per se, as we know, they came out as a proposal from the International Commission. There was, of course, even the proposal of the origin from the ILC to the UN General Assembly to adopt a treaty based on it, but then, of course, the International Commission did not include a series of provisions, which, on the contrary, would be required for the text to become a treaty. In this regard, indeed, Therese O'Donnell, she's a professor at the University of Strathclyde in Scotland, can provide some insight of which measure or which provision could be expected to be present and discussed by states, or to take into account other multilateral treaties currently or recently negotiated. So this might also permit to understand what might be also the role of the regress movement between the new treaty itself. So Therese, it's up to you.
Many thanks, Giulio, and many thanks to all of the organisers and participants in this fantastic webinar that we're all enjoying this afternoon. My role will be to address, if you like, almost the afterlife of any potential treaty and the provisions that could be inserted to take account of that. And I'll be discussing potential additional articles and indeed the possibility perhaps of using annexes to any final treaty to, in a sense, provide for that operation, implementation and legacy of the treaty. I'm going to be looking at four main issues. I'm going to be looking at implementation and monitoring of any treaty operation, drawing upon potential models that have been utilised in other international law governance systems. I'm going to be looking at the potential for dispute resolution, possibly in the context of mediation and conciliation, as drawn upon again from existing models, some regional, some human rights models. I'll be looking at the possibility of a conference of parties to be provided for, and I will be touching very briefly at the end on the issue of observer status that might be accorded to organisations. So first of all, as Marie has mentioned, the Sendai midterm review has noted that although improving, there are ongoing issues with the implementation of risk reduction, monitoring and prevention measures. And as we all know, the disaster cycle sees preparedness as key. There is therefore a keen interest in ensuring that states are implementing and cooperating with each other and with other non-state actors and the like, such as IGOs and the like, to safeguard communities from the worst effects of disasters. Such preparedness doesn't just include technological challenges, but also things like legal preparedness. Now, there are two opportunities I see. There is a monitoring and review possibility within the treaty itself, if there is to be provision for that, and one outside the treaty, which I will talk about in a second. So these are two options that I would posit at the moment. The first might follow the model of the, in a sense, periodic review processes of various human rights bodies. So the UN Human Rights Committee, the CEDAW Committee, CRPD Committee, and CERD, the Committee on the Elimination of Racial Discrimination. Therefore, a dedicated treaty body could be provided for within the instrument itself. This would institutionalize and structure post-disaster or even disaster risk reflection and review. It would allow for expert appointments to be made to that committee, and there would be the possibility of a reporting process. That reporting process could be done via states reports to the committee and the committee's concluding observations on how states are performing. The committee itself could also report annually and biennially to to the General Assembly and or to states parties. Okay, so that could be an ongoing conversation between the committee and states. That could be perhaps in tandem with a COP or something along those lines. You could also allow, given the need for an all-of-society engagement approach, shadow reports from NGOs. And this very much follows the model of the human rights approach. More recently, there's been the possibility of inquiry procedures opened up under optional protocols that have been added to human rights treaties, such as CEDAW and again, the Disability Rights Convention, where there is a much more proactive approach by the committee. It moves from a passive role of receiving reports to an active role of investigating. It's met with some mixed success in those other treaty bodies, but it makes the committee a much more active observer of what is occurring within states. That might be quite an attractive option for such a body. It, of course, might meet with a certain amount of resistance. It might be considered to be too penetrating of sovereignty. One other point that such a committee could do is it would allow for it to perhaps produce general comments and general recommendations on the operation of the treaty and interpretation of treaty provisions, which might actually be a very helpful interpretative instrument going forward. There are challenges with that. There's often a lengthy time frame between states' reports, considerations and feedback. Perhaps it is too focused on states. One might receive insufficiently detailed reports from states. It might indicate a more combative tone rather than a partnership. It might be seen as an ex post facto approach and not be proactive enough for what we're looking for. And it does not allow for such committees to directly address NGO activity. It would retreat to due diligence of states. It's also unlikely that an individual communication procedure would be useful here. It also might be said to be that this treaty is not a human rights treaty, and therefore it is not appropriate to use that model. However, I would suggest that it is available as a model to play with, to have in mind. That's if we put an implementation body within the treaty. If that is not taken, then the possibility is to look at a monitoring mechanism outside of the treaty, to leave it to another body to do that. The possibility here, or one of the models, would be following what has been used in relation to counterterrorism or sanctions, which is a United Nations Security Council Committee type model. Not suggesting the UNSC is the way to go, but it's one potential model. That would look to improve national capacity, as it has done in the counterterrorism field, and to facilitate assistance. It is assisted by an executive directorate, which might be quite appealing again. However, this probably has overtones of securitizing the issue of disasters, which we might not really be too keen on. There will be sovereignty concerns about that. There's been charges that such committees are acting ultra vires. And as I say, it might go against the tone and tenor of the PPED Convention. However, these are two potential models of implementation and oversight of the treaty's operation. Turning to dispute resolution, there are two models that I would mention. These would be in the context of mediation and conciliation. Mediation has, of course, been extensively used in the field of international investment law, commercial law, trade law, and intellectual property law. At the moment, we have regional mechanisms that facilitate operational and logistical support through the EU Civil Protection Mechanism and the ADMIR and AHA Centre in Southeast Asia. These provide mutual assistance and support, but they don't have a formal mediation mandate. The UN Mediation Support Unit is currently focused on peace building and armed conflict context, so not really, perhaps maybe in a complex emergency, but otherwise not really relevant to what we're discussing. Conciliation models are already in use in human rights treaty systems and again conduct more of an inquiry type role. I would suggest that mediation and conciliation are untapped resources in the disaster milieu, and they might be fitted within our treaty in a number of ways. They have a lot of attractions because they offer political discretion, particularly in the context of Article 13, the current draft Article 13 and aid refusals. I think particularly mediation would have a role to play here. It would avoid the febrile referrals or threats of references to the Security Council or the International Court of Justice. Could it fit elsewhere rather than having a separate process, a separate provision? Yes, it might fit within Articles 7 and 8 as a form of cooperation to introduce a notion of mediation as a form of that. Alternatively, it could be a separate provision. But what it will do is it will avoid ad hoc approaches based on the goodwill of states. It would create a standing structured process whereby states could remain part of that process, but there could be a focus on humanitarian needs and a certain amount of inclusivity, trust, and avoiding of confrontation. It might be argued that more bodies or institutions are not desirable. That's just, that's entirely possible. But at the moment, there is no mechanism at all. And given the tone of states' comments in relation to Article 13, I would suggest there's a crying out need for this. Turning to my second last point on the Conference of Parties possibilities, again, this is a standardized treaty governance model following the climate change world, the tobacco control, the more recent pandemic agreements. There's no uniform model. It's driven by subject matter and needs, and it's very extensively used in environmental law, which has much in common with the disaster field. The attractions would be secretariat support, expert subsidiary groups, guaranteed meeting time, public scrutiny, and the capacity to again involve other stakeholders beyond states. Again, this might be able to deal with controversial clauses and possibly moving certain provisions to, these could devise annexes that ultimately would be part of the treaty system. In terms of observer status, again, this would follow the climate change, the Framework Convention on Climate Change model, and would allow for an online admission system for organisations with expertise to participate, or to have discretion to not admit such bodies, depending on voting patterns again. So I think that we can think of some very obvious bodies who would be highly eligible and highly appropriate for such observer status, and this perhaps needs to be recognised in the treaty. And I will stop now.
Thank you, Therese, to highlight potential future final clauses of the treaty itself. In this regard, and as to finalize this first round of presentation, then to open the floor for participants, all participants, particularly for national Red Cross and Red Crescent societies, are aware how the IFRC recently released in the past month a set of proposal for a technical proposal for the for discussion for states, which of course I would encourage you, particularly once engaging with advocacy activities with your own government, to take into account. And in this regard, we have the pleasure to have with us Yannick Serradino from the IFRC, with whom also we cooperate to elaborate such a document with other colleagues, provide some suggestions as well. And of course, Yannick is very well placed to present on a world perspective the proposal made by IFRC with regard to the set of provision we have just addressed. And after Yannick, we might open the floor for everyone for questions, so you can already start to make your point eventually in the chat, or then again, as mentioned, raise your hand, and then we can permit you to open the video and the audio and so far and so on. So Yannick, thanks for joining, and looking for listening to IFRC presentation.
Thank you so much, Giulio. I'm going to quickly share my screen. There we go.
Yeah, it works. It works.
Perfect. Thank you so much. I first would like to just say thank you very much for the opportunity to speak today. And I would also like to thank the previous speakers for their really rich and thought-provoking interventions. You will see that a lot of what I'm going to present today really underscores a lot of what has already been said, but I do hope that my presentation nevertheless offers some unique perspectives. National Red Cross and Red Crescent societies, I believe, have seen more clearly than anyone else how disasters have become a part of everyday reality, devastating families and communities around the world, and why a legally binding instrument on the protection of persons in disasters is critical. It not only provides an opportunity to clarify and consolidate states and other assisting actors' obligations with respect to the management of disasters and disaster risks, but it also has the potential to save lives on the ground, which is really at the heart of our work. Earlier this year, the IFRC, with the support of several academic partners who have spoken today or who will speak next week, developed detailed proposals for amendments to strengthen the draft articles for the consideration of states ahead of the upcoming treaty negotiations. Our proposals are very much focused on advocating for a treaty that makes a difference on the ground. The proposals cover the full scope of the draft articles, but given that this webinar is focused on draft articles 1 to 9, today, I will only focus on how the instrument has the potential to ensure that all people are protected in disasters, especially those in vulnerable situations, enhance cooperation among states and between states and other assisting actors in DRM, and ensure that disaster risk reduction is prioritized across all sectors before, during, and after disasters. And then I will also just briefly touch on potential final clauses. Before diving deeper into these points, I would just like to first touch on the scope of the instrument. Over the past decades, there's been a significant shift towards comprehensive disaster risk management, moving beyond a sole focus on response. This includes a broader focus on disaster prevention and mitigation, preparedness, and resilience building. The draft articles, on the face of it, are largely response-focused. But in line with the shift, the IFRC proposes that many of the provisions should be expanded to explicitly cover all elements of the DRM continuum. This will support the protection of persons, strengthen cooperation, and also support the prioritization of DRR. Then moving to the 3 specific topics. With respect to enhancing the protection of persons in disasters, we have seen time and time again the far-reaching impact that disasters can have on human rights, deepening existing vulnerabilities and inequalities while also creating new ones. In many crises, the impacts of disasters are also not equally felt. For example, women and girls may face heightened risks of gender-based violence or loss of livelihoods. Persons with disabilities or chronic illnesses may be unable to access shelters or evacuation routes, and migrants and minority groups may experience discrimination in aid distribution. As the title suggests, the draft articles place a central focus on the protection of persons affected by disasters, including their human rights. The draft articles establish that human dignity must be respected in draft Article 4, while draft Article 5 is dedicated to the protection of human rights, and then draft Article 6 provides that disaster response shall take place in accordance with the principles of humanity, neutrality, and impartiality, while taking into account the needs of the most vulnerable. These elements are critical to enhancing the protection of persons in disasters, but our proposals are that they can be strengthened by increasing their scope across the whole DRM continuum, as well as recognizing the right to humanitarian assistance, and also recognizing the principle of independence. And then finally, including a non-exhaustive list of concrete measures to strengthen the protection of persons in vulnerable situations in DRM. Essentially, if these provisions of the draft articles are included in a binding global agreement, and particularly if they are strengthened as outlined in our proposals, they could ensure that human rights are placed at the center of the management of disasters and disaster risks. They can concretely protect persons in vulnerable situations, and they can ensure people-centered, principled humanitarian action, ensuring that no one is left behind when disasters strike. With respect to enhancing cooperation among states and between states and other assisting actors in DRM, cooperation is really at the very heart of international law. Treaties are fundamentally instruments through which states coordinate their actions, share responsibilities, and pursue common objectives based on mutual consent. In the context of DRM, key international instruments such as the Sendai Framework, regional instruments, resolutions of the United Nations General Assembly, and resolutions of the International Conference of the Red Cross and Red Crescent all recognize the central importance of cooperation. The draft articles themselves do too, in draft Article 7, which provides the duties to cooperate, and draft Article 8, which enumerates forms of cooperation. As we face increasingly variable climate and disaster risks, cooperation both within and across borders is more critical than ever, and a treaty on the protection of persons in disasters has significant potential to strengthen cooperation and coordination between states and international and domestic partners, while also protecting state sovereignty. In terms of our proposals, any duty to cooperate included in the treaty should explicitly apply to all aspects of the DRM continuum. In addition, the enumeration of the forms of cooperation that are included in draft Article 8 seem to miss some important aspects, such as strengthening legal and institutional frameworks, training, capacity building, information sharing, joint simulation exercises, dedicated financial support, and assistance with evacuations. These should be included in the future instrument. In addition, in order for cooperation to have the most significant and sustainable impact, it cannot be limited to states. While it's recognized that each state has the primary responsibility for managing disaster risk, consistent with the principle of state sovereignty, the efforts of other assisting actors, including local actors such as national societies and regional organizations, are really indispensable to ensuring effective DRM efforts. Therefore, the PPED treaty should recognize the role of other assisting actors in provisions promoting cooperation, including local actors, and explicitly recognizing the auxiliary role of national societies, and also including the role of global, regional, and sub-regional intergovernmental organizations. Moving to how the treaty could ensure that disaster risk reduction is prioritized across all sectors before, during, and after disasters, it's clear that the Sendai Framework has driven really major progress in raising awareness and strengthening national systems for disaster risk reduction. But reports have shown that implementation does remain uneven, and the world is not on track to realizing the framework's goal by 2030. The draft articles already emphasize the critical role of DRR through draft Article 9, which recognizes that states have a duty to prevent, mitigate, and prepare for disasters by taking appropriate measures, and it includes a list of disaster risk reduction measures. This article is really crucial and a good starting point, but it could nevertheless be more detailed. For example, it should reference the mainstreaming of DRR into not only legislation and regulations, but also policies. And this is because certain countries don't necessarily have binding DRM legislation and rather regulate DRM through policy instruments. And then in addition, it should include a wider range of measures than currently included. It could also require that states have due regard to evolving best practice in the management of disaster risk. And this is proposed to avoid any concrete measures that are included within the provision from becoming outdated. And then finally, it could include an obligation for states to establish or strengthen national platforms for DRM following the success of national DRR platforms which have been established to date. These platforms can be really crucial mechanisms to support states in their efforts to achieve their obligations under the treaty. If similar binding obligations are included in the future instrument, states would essentially be building on the commitments made under the Sendai framework, creating stronger legal incentives for states to invest in DRR, embedding DRR responsibilities across all sectors, ensuring that authorities responsible in different areas such as disaster risk management, climate, health, housing, agriculture, and the environment work together to manage disaster risks, and also encouraging stronger cooperation in DRR to help states overcome financial and technical barriers that they may face. Then finally, with respect to the final provisions or potential final provisions, the IFRC recommends that states should establish some formal mechanism to review and monitor the implementation of the instrument. It should also adopt decisions or annexes and adapt to evolving circumstances and emerging challenges in DRM. Such a mechanism can ensure ongoing relevance and effectiveness of the instrument by enabling regular dialogue, cooperation, and accountability among state parties. In addition, the IFRC is advocating for a role to support states in the implementation of the PPED treaty. While the specific role of the IFRC under the instrument is of course set to be determined by states, the IFRC would need to fulfill any potential role in full compliance with the 7 fundamental principles of the movement. Given the IFRC's extensive experience and capacity in the humanitarian field, the organization would be well suited to serve in a formal technical or advisory capacity, contributing specialized expertise on humanitarian and disaster-related matters, supporting monitoring and reporting efforts, supporting research and development, and advising the instrument's governing and decision-making bodies on implementation issues. This would be consistent with IFRC's mandate on disaster law, which has been established through resolutions of the International Conference of the Red Cross and Red Crescent. In addition, speaking of the International Conference, this is a platform that has already been established as one of the key international forums for continued dialogue on strengthening legal and regulatory frameworks for DRM. As such, the International Conference could provide a strong platform that can be leveraged for continued dialogue on the protection of persons in disasters and support the implementation of the treaty in domestic legal contexts. Finally, before wrapping up, I just wanted to highlight that the IFRC proposals are available on the Disaster Law website, and we have also created a suite of additional tools to support national societies in their advocacy efforts on the treaty. This includes key messages, a summary of the proposals, several speaking points, a PowerPoint presentation, and terms of reference for dissemination events. We've also recently developed a set of fact sheets on topics relating to the treaty, such as how the treaty can strengthen external assistance, protection, and DRR, and also how it can enhance the auxiliary role. We're also currently finalizing a fact sheet, a Q&A, like a frequently asked question sheet. We're also developing a dedicated space within our website for the treaty, which will contain many of these tools. And I think many of you are aware of the community of practice, and they're also available through that platform. Thank you so much. Please do not hesitate to reach out in case of any questions or comments. Thank you.
Thank you, Yannick, for your presentation of the IFRC position on this first set of provision. As said also before, and also mentioned in the chat, there are two ways to contribute to the debate by participant. So basically, one is to provide some question in the chat. I already see a question from Michael that we might address. And then the other one would simply be to raise your flag that you would like to make a live question, so you can open the video and the micro for your benefit, so you can arrange. So the first question is general one asked by Michael, and partly Isabella already provides some points. Basically, Michael Meyer from the UK Red Cross was asking basically what are the most contentious issues or article in the draft articles so far, based on this position made by states at the 6th committee, which is the UN General Assembly Committee for Legal Affairs. On that, Isabella was already flagging. I don't know if you would like to speak on that, and then eventually my compliment, because the answer by Isabel is already in the chat, but I don't know if Isabel would like to make some live remark on that.
Sorry, yes, thank you, Giulio. So yes, IFRC participated in the general debate, and I just flagged here some of the comments that were mentioned frequently by states. So of course, the definition of disaster was raised many times by states as well. Many states requested for a stronger emphasis on state sovereignty, non-interference, and consent, and as well the recognition of the state's primary role in DRM and the protection of people. There were also many requests for enhanced coordination and support across the full cycle of DRM, and also stronger linkages with regional mechanisms such as ASEAN and ECOWAS and others, and also increase capacity building and technical assistance to be recognized and provided in this treaty. This is not an exhaustive list, but what I can mention is that this is not the first time we're hearing about that. I think throughout the working group that took place as well in the 2 previous years, these were also some of the main points that were raised by states in those discussions, but these points are still on the table again, and they were discussed at the general debate. Yeah, again, this is not an exhaustive list. Thank you, Giulio.
Yeah, indeed. Also, just to remark this point, these are for sure some points that states raised. Also, Marie was mentioning how for disaster risk reduction, even if there is a strong interest to have it, we still have some backlash by states who would like to substitute, for instance, the current wording which pinpoint to a concrete obligation with the states shall do something with more vague terms like states should act with regard to disaster risk reduction, which on the contrary, Marie was strongly advocating for, on the contrary, a strong provision on that. Then Michael was also making a question to which might be addressed also to Emanuele. Basically, it's about the definition of other assisting actors, which basically in the current text is in the current text of other assisting actors, and you can also see with the proposal made by the IFRC, the idea would be to enlarge it. I don't know if Emanuele have some specific comment on that. Basically, Michael was asking, currently, the current definition refers to relevant non-governmental organization, while, for instance, the proposal made by the FRC is to extend it also to specify also how it includes also local and not only external actors, because basically this was one of the main one of the challenges in the current text, which is mainly devoted to looking at external actors coming to provide assistance and not paying so much attention on local actors, domestic NGO, which, on the contrary, also from the IFRC perspective, might find more room in the discussion. So I don't know if Emanuele see the question in the chat and
yes, thank you. Yes. Yeah, I mean, Michael is perfectly right in the sense that so my impression is that when they were drafting the provision, they obviously had in mind international actors. So because the initial idea was to, I think, more create a treaty which would facilitate international assistance. And this is somehow also reflected in the definition of disaster, because it says that the disaster must be such that the local functioning of society must be completely disrupted, which basically means that the state is not able to tackle the consequences of the disaster autonomously. So I think that, yes, and I think I even hinted at it when discussing the preamble, including non-state actors in the preamble or in mentioning them also in other parts of the treaty would obviously be an added value. I also think that we must take into account who actually does and carries out these sort of missions nowadays, right? And so if you look, for instance, at the European level, the European Civil Protection Mechanism is all entirely based on national assets that are sent abroad in order to assist countries which are affected by disasters. So one additional point which could probably be mentioned is to make explicit reference to regional organizations, because usually many countries you see that reaction to disasters is regulated so that you start from a local level, then if the local level is not enough, you go to the regional one, then to the state level, and then maybe you could involve, you could proceed in this sort of Chinese, how do you say, boxes thing, go to the regional one, and then if even at the regional level the assistance is not enough, then. But then I see also the counter argument here that sometimes you simply reach out to all sort of to everyone who can assist you, so you do not really have time to sort of exhaust all these avenues one after the other. But bottom line, yes, I do think that national actors should also be considered, especially because in humanitarian assistance, as in development cooperation more broadly speaking, sometimes international actors want to play, to have the lion's share, whereas many times local contributions and contributions by local actors should be somehow given prominence, in the sense you don't want items, assistance, relief workers to be so imported from outside if you already have them available at the national level. And so this is why I see disaster preparedness as a key element, and I agree with Marie in the sense that one thing that all states should do is to better prepare their own national assets, their own civil protection, their own NGOs, so that they're able to increase their response capacity, and so that maybe international assistance won't be necessary in the first place. I don't know if I answered the question.
No, I think you perfectly replied to the question. In the meantime, I was also projecting in the screen, if I'm right, the comparison table between, on the left column you have the current text, and on the right column you have in bold the proposal which were made by the IFRC. And also, as mentioned by Emanuele, we can see how an idea would be to better flag who might be the potential assisting actors, and you can see also how, which of course include, better specify the role of the UN and also other global, but also regional, sub-regional organizations in this area. But also from, let me say, from a perspective of the Red Cross movement, I think there is a room for asking states, and that's also a role that national society might have in lobbying with their own states, to have a clear reference to dimension of the components of the Red Cross movement, also particularly national societies in light of their auxiliary role to the public authorities in the humanitarian field, to be explicitly flagged in the next treaty. This would also be relevant to provide national society to give a further legal entry point for activities with states in relation to humanitarian activities in case of disaster. So that's something, that's the reason why IFRC highlighted this point as one of the potential amendments that states should pick up, as well as the reference to local NGO, take into account how on the original mindset of the draft articles was for external assistance, while there are multiple activities, as also Manuel was mentioned, also Marie was mentioned, about domestic actors which can play a role, particularly in preparation for a disaster, and that's also why probably some adjustments should be made. So now I stop this to share the screen. Okay, I'm fine. I see also other questions which were there. So one question I think is for Doug, might be, what about to merge the draft Article 4 on human dignity and 5 on human rights? Does it make sense? Will be lost something, or will be not value, better clarification, whatever? Just please.
Certainly, no, thank you for the question. And that was really the Special Rapporteur's original approach, where there was an article on human dignity, then an article on humanitarian principles. I personally think that there's a benefit keeping the two separate, keeping one article on human dignity and one on human rights, on the basis that human dignity is an overarching principle that applies, whereas when we reference human rights law, we can start getting into more detailed provisions around the right to housing, the right to shelter, the right to medical care, and so forth. So I think there is a usefulness in keeping a separation between the two articles. I think there may be discussions around whether the reference to human dignity is moved to the preamble rather than having a specific operative article. As I mentioned in my comments, I do think that there's a benefit. The ILC was clear that they thought there would be clear legal obligations arising from Article 4. Perhaps if it's very much is just seen as an overarching principle in the preamble, it may not be seen as having legal effect in the same way. So I would certainly argue that keeping the two separate and keeping two operative articles would be an important component of the convention. And if I may, Giulio, that may link to then the question around what are some of the key things for national societies. As a volunteer with the Irish Red Cross myself, I do think, and perhaps I'm biased, but I do think those human dimension articles are really important for national societies to emphasize. I do worry at some of the sort of retrenchment from human rights globally at the moment. So I think it's important that we keep strong language, and that's another argument potentially for keeping separate articles on human dignity and human rights. So there's a very strong human element within the draft articles, and it's not simply about sovereignty and the technical requirements of how states cooperate in humanitarian assistance. Thanks.
Good, Doug. So there is also a question by Yanni from the Finnish Red Cross. I don't know if Yanni would like to make it live, or otherwise I can read it. So
Yanni's there. Yanni's there.
Yeah. Can you hear me?
Yes.
So one of the things that we've discussed is to try to identify what we as a national society would like to convey to our public authorities, be that the Ministry for Foreign Affairs, Inter, or the Social Affairs, etc., with regards to medical. So from your perspective of the provisions that we've talked about today, what both, I guess, from Federation, but also from the academics expert side, what would you feel is the most critical issues or pointers we would need to make to our own government representatives? Either they're saying this should not definitely be taken out or weakened, or alternatively something added or amended in the current text or the totality. Thanks.
Thank you, Yanni. Yes, I would make it to the top, I would say, on that. So maybe if each of the speaker might think about a specific point that from a national Red Cross Red Crescent society vantage point, what is really relevant in the potential amendment to be taken both in regard, let me say, to their own set of draft articles or eventually in general point. Emmanuel. And then, of course, Yannick will have the last word because she's and Isabel for the IFRC. But first, let's see academics what they think will be relevant for national society to keep on board or add.
Yeah, well, I do not have any specific point. I think what national society should do is to remind the governments that many states already have concluded treaties regarding disaster response at a bilateral treaty, at a multilateral treaty. So it's more likely than not that their legal systems won't need to be changed much if they decide to join a specific treaty on disaster response at a universal level. So I think that the most reassuring thing that you can tell to the relevant stakeholders in your respective countries is there is nothing really new in that. Of course, there are some provisions that are a bit more controversial concerning, I don't know, the arbitrary denial of consent to foreign assistance, for instance, or whether third states have an obligation or not to provide assistance, even though the ILC has cleared these issues in the commentaries, for instance. But still, I mean, I think the most important thing is to give them some peace of mind, saying, okay, yes, that's a new treaty, that's a universal treaty, but it's nothing really new with respect to the sort of undertakings that we already have concluded over the past few years. I mean, it's not like 50 years back when there was literally no treaty about disaster response, right? Now we do have treaties, and now we also have many documents, even though mostly soft law documents concerning disaster risk reduction. So I think we should sort of, or you should rather say, send a message of tranquility and peacefulness to your own government, saying, we're not embarking in some new and unexplored, uncharted waters here. We are doing something that we've done in the past. Thank you.
Doug, Marie, and Therese. Yes.
Certainly, I'll just very quickly echo what Emmanuel is saying, in that this is primarily about codification. The International Law Commission themselves were quite clear that a lot of what's in the draft articles, it's part of international law, even if it hasn't been perhaps pulled together into one instrument in quite the same way previously. So I think the duty of international cooperation, I mean, that's a long-standing principle of international law. So reinforcing these elements with national society or for national societies, for governments. Perhaps just one comment for those of us coming from countries who are primarily donors as well, perhaps emphasizing the duty of cooperation on donor states as well to support other nations who are perhaps more vulnerable to the impacts of climate change and disasters. And therefore, for those of us, whether it's in Finland or Ireland or other countries, perhaps just emphasizing that role, that we also play an important role as donor states in this system.
Marie and Therese, and then we give the floor to Yannick.
Thank you, and thanks, Yannick, for a very, very interesting question. I think, yeah, first of all, I think it's really stressing the importance of driving this home, and that this is something really, really worth doing, because it's one thing that they're in favor of it, but it's another thing to have that they're willing to fight for it. And one argument that I'm not sure has been mentioned yet, but it's been hinted at, I guess, part of the donor country role. It's both for countries like Finland, but also wider if you're working with colleagues in the EU, and for Finland perhaps, and other countries who are in the EU, where there are other states that might be hesitant, to really emphasize that this is really enhancing the operability of existing mechanisms for external assistance. Whether that is incorporating DRR measures, but also actually putting this in place would really help EU, who is a large donor organizations. There are large donor states, to actually really get value for money as well. So it's like, if they are concerned about that in circumstances where the humanitarian space is shrinking, that is something that actually that will be value for them. You know, this is a good thing, even not just a moral good thing, but this is also something that can be valuable. So if you have states that are hesitant, I would push that. And I mean, I made the point before, the importance of keeping the holistic view on disaster risk management and to make sure that prevention is in there. Thank you.
Thank you for that question. I think that implementation, monitoring and review is going to be crucial to some live nature of this treaty. And I think that can be done depending, I mean, the COP can perform, proposed COP can perform that function, but if you're more concerned, and that might allow for a kind of alteration of the treaty as things go on, or an amendment or additions. But just what I said already, the other alternative is more a monitoring of state performance under that treaty. Now, I appreciate that this isn't, you know, adding new obligations, and states shouldn't be scared of the PPED treaty, but at the same time, we want to have some sort of vigilance and some dedicated venue for overseeing, implementing and reviewing this treaty. Because to scatter it to other bodies, I think, is going into reverse on the whole motivation for this treaty. So I think there has to be dedicated venues, sites, times, or some form to make sure of some dedicated oversight and implementation. So that would, for me, in light of what I've been talking about today, that would probably be what I would be saying to the IFRC and to national societies. Thank you.
You're on mute, Giulio.
Yes, I see. And from the IFRC, with regard to this specific set of draft articles, so 1 to 9, and plus the potential final clauses, so what might be the most urgent points to mark to national society in their engagement with government?
Yeah, maybe I take this question. I think it's really hard to answer this question because, of course, the IFRC represents a membership of 191 national societies, and the priorities in each country will be different from one country to another. So it's difficult to just, you know, basically isolate one recommendation over another. This being said, of course, one common message to all is that, you know, we do encourage authorities to engage in this process and support this treaty. In the last general debate, there was around 80 states who provided a statement, who are actively engaging. But again, I mean, the next 14 months will be critical, and we hope that more states will engage and support or recommendation in this treaty, make sure that, you know, it provides for the protection of person in disaster, that it have impact on the ground, and basically resolve the problems that all humanitarian actors have been facing in disaster risk management and disaster risk reduction for so many decades. So these are just some of the, of course, you know, this is a general but important call to national society to continue engagement with their authorities, asking them to support. So the focal point at the moment is with the Ministry of Foreign Affairs at country level, but of course the Ministry of Disaster Risk Management also have a critical role to play in advising this process. So we do encourage national societies to engage actively with both ministries. I'll stop here.
Thank you, Isabel. And then we also have Michael. I don't know, Michael, if you would like to make your question live on Article 6. I think Tommaso put you with the speaker role, so if you want, otherwise I can read your question.
Okay, thank you. I'm not sure I'm able to be seen, but maybe
yeah, I can hear you properly. Yes,
good.
Yes.
Okay, thank you. And could I first of all thank all of you. It's been really valuable. Thank you. On Article 6, we are aware that there are different definitions of the humanitarian principles. Is this a problem for us? Thank you.
Thank you, Michael. And that's it for Doug, for sure.
Sure. Isabel, do you want to go first, or do you want me to?
Go ahead, please.
Certainly. So thank you for the question, Michael. And yes, this is obviously one of the issues, as I was mentioning, the fact that independence isn't included at the moment, the fact that non-discrimination seems to be separated out for impartiality. There's questions even around the structure and the way that the current wording of draft Article 6 is. So I think there does need to be some rearrangement of that article. In terms of the definitions, I guess from my perspective, and I'm looking at it perhaps, well, a member of the movement, looking at it more from the perspective of how they're used within UN, say, General Assembly resolutions and so forth. The 7 fundamental principles of the movement obviously have their definition. If we look at how over the course of more than 30 years now, we have had the 4 principles used within the strengthening humanitarian cooperation resolutions by the General Assembly. And I actually think there would be a benefit for including the 4 articles explicitly. As we know in IHL, the principles perhaps don't necessarily have full definitions. So I think it'd be useful to include them. Do we need to then include a definition within Article 3? That's perhaps another question, or maybe it goes to what Therese was saying about having some sort of monitoring body that could potentially do general comments or so forth. So I think it does become a question of how much should be included within the convention itself in terms of definitions, and how much should be provided expert interpretation by another body. But I personally think having the four humanitarian principles on the basis of the UN General Assembly resolutions is probably the best way forward, because there's fairly well established agreement from states about including those 4 humanitarian principles in General Assembly resolutions. Thanks.
Thank you, Doug. Isabel, want to comment something?
Actually, I don't want to take the space from Janique, so maybe let's leave Janique answer.
Sure.
Thank you so much, Isabel. And I completely agree with what Doug mentioned. And also, I think it's a really good question, Michael, specifically given, that the 4 fundamental principles that are in the draft articles are, part of the 7 fundamental principles of the movement. So of course, this is a critical issue for us to ensure that there's, not this confusion, that this confusion doesn't arise. So I think that this is perhaps a point where national societies, when engaging with their governments in the run-up to the negotiations on the treaty, this is perhaps a point of discussion, to ensure that there is an understanding of these principles, and to ensure that, in the treaty negotiations, if the definition is included, that it doesn't add to any confusion, and that, it's rather clarified rather than the waters are further muddied. Thank you.
Thank you.
Thank you, Michael, for the question, and Janique and Doug for the helpful answer to the point. I see also Tristan Ferrara from the IFRC, who is making a point, which is, I don't know if Tristan might or can, let me say, open the mic. I would like to make it straight. Otherwise, I can read the point made by Tristan, which is basically for the International Committee of the Red Cross, which of course is a point made by Tristan in relation with the previous request or comment by Yanni on what might be the most urging point for national society, is that national society should convene the point that the definition of disaster exclude armed conflict, which is indeed one of the points which is in the current proposal made by set of proposal made by the IFRC. Indeed, you can see how the current definition of disaster is broad enough that might potentially also include the effect of an armed conflict in the definition. But if you already read the commentary to Article 3, letter A, it clearly mentions how an armed conflict per se could not be identified as a disaster for the scope of application of the potential treaty. So usually there is, let me say, this sort of risk of losing key points from the current text of the draft articles because several elements, crucial elements even, are present already in the commentary, but of course the commentary will not be part of the treaty. So there is for sure a need also for national society to suggest states to make a series of proposals to, let me say, upgrade some key elements present in the current commentary into the plain text of the treaty itself, and indeed the exclusion of armed conflict from the definition of disaster is also one of the points that the IFRC was mentioning in this regard, also to keep, let me say, the future text in line with other instruments of disaster law. So that's for sure a point that Tristan was making as a suggestion for national society, which for sure has a legal value, but also, let me say, value for national society to keep a proper balance on that. I see Yanni has asked the floor. For sure, you can, I think, already open your micro, Yanni.
Yeah, just as a clarification. Clarification as to, for complex emergencies, you have a natural disaster in an armed conflict area, would that be excluded or not? Because here it's sort of, but excluding armed conflict, meaning is that the cause or the context?
Yeah, Emanuele can complement, and then otherwise I can. Emanuele already knows the answer.
Thank you. Yes, as I was mentioning, I agree with Tristan's proposal that maybe national society could push to clarify this issue, not only with respect to armed conflict, but also to other situations of violence which might not yet amount to armed conflicts, but which might cause consequences that, if you read the current definition, the draft articles, might come close to the ones of a disaster. So we want to make sure that the draft articles only apply to, let's say, genuine disaster, if you know what I mean, right? And so that armed conflicts are excluded. So if there is an armed conflict, you cannot apply per se the draft articles. Another issue is the one you mentioned, Gianni. So if you have situations where IHL applies, so there is an international or a non-international armed conflict, and there IHL applies, and IHL obviously should play the primary role in regulating everything, including humanitarian assistance, right? Because as a matter of fact, many provisions of which have been included in the draft articles were transplanted, so to say, from IHL treaties. So what happens though if you have an armed conflict situation and then in the same territory where, technically speaking, IHL applies, there is a disaster? Now, there, I think we should look at the final clauses of the treaty, where the relationship between the treaty itself and other rules of international law are laid out there. And the solution that has now been found by the Commission is, okay, there is a no prejudice clause saying that for all issues that are regulated under IHL prevails. Question is, are there any issues which are not regulated under IHL and for which the draft articles could sort of support, let's say, the assistance effort and make it more effective? If there are, I don't see why the draft articles, so the future treaties should not be applied. If there aren't, then it will only remain the realm of international humanitarian law. But it remains to be seen how states will let's say, regulate that specific relationship. But as far as Tristan's remark concerns, so disasters per se, as Giulio rightly said, should not be considered, disasters, armed conflicts per se should not be considered as disasters. I don't know if I was clear enough.
Yeah, no, for sure. And the Doug, you want to complement, I see.
Yeah, please, if I could just come in on that point, because I agree with what Emmanuel is saying. I think the one thing just to flag, obviously, and we know from experience, if we think about the 2004 tsunami in Sri Lanka or in Aceh, where you have civil war taking place, so internal armed conflicts, and we know that within IHL, the provisions on humanitarian assistance are lesser for internal armed conflicts and international armed conflicts. So I think we need to make sure that the highest level of protection is provided for people in a complex emergency. And so we may have lex specialis for IHL, but also hopefully these provisions around disasters would also then provide another layer of protection in a complex emergency, particularly, I would argue, in an internal armed conflict setting where IHL perhaps doesn't have as strong provisions as we might like for humanitarian assistance.
Yeah, no, thanks a lot, Doug, which already, let me say, both of you create a bridge to the appointment to take place next week, where we are going to have the second leg of this webinar, where indeed also draft article 18 will be addressed. So there will be further food for thought on that. I see we are going to end the time of our meeting, so I don't want to take more time to our speakers as well as to staff and colleagues from the National Red Cross and Red Crescent Society. I would like to thank all of them for that, and also IFRC for hosting us today. So from my side, it's all. I just want to emphasize how next week on Tuesday we are going to have the second round of the webinars. Also spread the word in case the webinar was of your interest. You can of course also mention it to other colleagues in your national study or in other national study with whom you are in contact, because of course there is a strong need of engagement by national society in the forthcoming diplomatic process, also in view of the deadline by the end of this year for national society, for states to provide comments in this regard. And also the group of academics here, which is broader, we are around 20 colleagues, is also ready to provide support to national society for their activities. Also, I think IFRC will soon create a web page devoted to list, let me say, the academics who are providing some support activities that might also be, let me say, of benefit for national study, but of course, the main point are for sure the IFRC regional officer. But before closing, I would like to pass the floor to Tommaso, who have a series of relevant information to share with you in this regard.
Thank you, Giulio, and also thanks to all speakers, colleagues, friends, academics who joined today. I think it was very interesting webinar discussion. Thanks also, of course, to participants and those who actively engage in the discussion. I will just take literally 1 minute. I just wanted to remind to all participants that an informal group of Red Cross, Red Crescent national societies was established a few months ago, which is supporting the diplomatic process towards the adoption of the PPED treaty, and counts now 31 national societies from all regions of the world. Many of them are represented here in the webinar, others are not here with us. So I just wanted to reiterate that you can easily join this group. This proved to be already a useful network for aligning respective efforts in our domestic context, but also at the international level. It also allows us to receive constant updates on all relevant developments in the process, particularly from the UN in New York, but also share good practice from our respective national context, which could inspire our future engagements in advocacy and humanitarian diplomacy initiatives in the near future. The second thing I wanted to tell is that there is an IFRC community of practice page on the Disaster Law Treaty that you can easily join by searching Disaster Law Treaty once you have logged into the COP, the community of practice, on the IFRC dedicated platform. And that is where you can find all relevant resources that IFRC and with the support of the Italian Red Cross produced over the last few months, including the recording of this webinar. So if you missed some part or want to rewatch some specific parts of the webinar, you will find the recording there. And also, of course, the recording of the second part of this webinar, which will be held next week on Tuesday, as Giulio was saying. And just to remind you very briefly that the second part will deal with the part of draft articles that address the role of the affected state, the role of assisting actors, specific provisions on the operational issues, but also relationships to other rules of international law, which were partly already addressed in the last part of this webinar. And also the IFRC perspective will be examined and illustrated a bit more in depth next week. So thanks again, everyone. Thanks for being with us. Thanks to all speakers. Thanks to Giulio and colleagues. And Isabel, see you next week. Bye-bye.
Bye-bye. Thanks a lot. Bye-bye. Have a good day.